Hi everyone, hope everyone's doing really well. So we had to abruptly stop our class last time. So in order to make up for the classes that we've missed, I thought we'll make short videos so that you can get the concept and materials without much waste of time. So as we were discussing in the previous class, we were talking about offenses being of two kinds. And offenses, one of the offenses that we were talking about was incomplete offenses, where at the stage of intention, preparation, and attempt, or where the person is not actively committed the offense or those in contradictory to the code. So the first of the one of the kind of inchoate offense is abetment. So if you remember when we studied parties to the crime, there were different parties that we discussed to be forming or who are parties to the commission of the crime. So it might be a person who has actually committed the crime, who is principal offender of the first crime. Then there might be people who have acted behind the scene of crime. One such stage is the principal offender of second degree, who is probably a person who has agitated or instigated the person to commit the crime. So that is where the punishment comes for such people. That is what is called as the offense of abetment, where the person is not directly committed the crime but has supported the commission of the crime. So that the Indian Penal Code, before we actually go into the offences, also talks about how where you're not directly party to the crime, but your involvement at certain stages of crime is also made as an offence. And that is what is defined in provisions from section 107 to 120, where the offence of abetment is made punishable. So, what are the important provisions that you need to understand is one section 107 what defines abetment, 108 that defines abettor, and 109 that gives the punishment for abetment. So you have three major provisions that comes important for abetment. And one another important aspect is 108A, which talks about what if abetment happens from a place outside the territory of India. Once you are clear with the concept of abetment, then you go into the special circumstances of abetment, which is given from 110 to 120. Okay, so this is how you look when you have to abet certain kind of offenses. All right. So next one is we're looking into what abetment means. Abetment is of mainly, as the definition goes, it can be of three ways. First is where you abet the crime or you prompt the commission of your involvement of commission of a crime in three different modes. The first one is through instigation. That is where you're actively provoking another person or pushing the other person to actual commission of the crime. This is not about a casual statement that is made, but where you have actively, with the intention that the person commits a crime, you provoke the person to actually do it. For instance, if a person A says that, see, I don't feel like living anymore, and B says, fine, why don't you just commit suicide? A casual statement of this kind may not be treated as abetment. At the same time, where you have a constant provocation, which in a reasonable man's mentality would have provoked the other person to actually commit an offense. All right, that is where instigation comes in. The second one is through conspiracy. Conspiracy, as you have referred to in 120A also. But what happens in this particular case is, in case of abetment by conspiracy, it's not sufficient that there is an agreement between the parties to actually do the act. Got it? Which is different from what is required under 120A. Under 120A, you're only required to have an agreement to actually do something illegal. But what is required in case of abetment by conspiracy is that an illegal act or an omission must have taken place as a result of that conspiracy. So there must be an aftermath of that conspiracy. Got it? I would have instigated someone or I would have got into an agreement with a person to commit something wrong. For example, if I've agreed to bomb, that's too much of an offense to commit, but bomb the university. I hope this video doesn't go outside. Bomb the university. And after that instigation, I tell my friend to do. If my friend does not complete the crime, I might have to face a liability under 120A. And as a result of this conspiracy, if my friend completes a crime of actually bombing the place, I would also be liable for having abetted the person in committing the illegal act as a result of the conspiracy. The third way is by intentionally aiding a person in committing the crime, where when there is a fight, for example, when there is a fight happening between the two, when you actively slips in a knife for so that as a result of this fight, A stabs B. I have intentionally aided in the commission of the crime by A for the murder of B. In that case, I've intentionally supported or extended my support in the completion of the crime. Got it? That is how we have three ways: abetment by instigation, abetment by conspiracy, and abetment by intentionally aiding a person in committing the crime. Now, this is what abetment means. Now, who is an abettor? Abettor is a person, nothing but a person who abets the commission of the crime, where the one who instigates, the one who conspires, the one who aids in the commission of the crime. What is important to face here is, even if the abettor is entering into is committing the offense of abetment with a person who is likely to be exempted under law, or in who may not be in a capacity to act with the same knowledge. For example, a lunatic person, a minor, a person under the age of 7. Even if I instigates, or if I conspire, or rather if I aid in the commission, I will still be categorized as an abettor. All right. So what is important here is, so if I am engaging a criminal activity by instigating a person who would have been exempted under law, I would still face the liability as an abettor under the Indian Penal Code. For example, where I engage a 6-year-old to steal something from someone else, even if the 6-year-old is likely to be exempted under the law, in at all possibility, who engages in absolute immunity, I would still have a liability for having engaged the 6-year-old as an abettor. All right, so that is what an abettor is: a person who engages, abets the commission of the crime, irrespective of whom the person is engaging that abetment with. Now, once you've understood what abetment is and an abettor is, we move on to what punishment for abetment is. There are mainly three categories of punishments when it comes to abetment. First category is, there are certain offenses where the abetment in itself is a separate provision of law for punishment. For example, abetment of suicide is an offense under section 306. All right. So that there are certain provisions of law where abetment of that offense itself is punishable. That is separately punished. But the situation here is where, in case there is no separate provision, what first category is section 109, where they say it is as if the abettor has committed the offense. So in case there is no separate provision of law punishing for the abetment of that offense, like how we have for abetment of suicide, a person would be punished as if he has committed the offense himself. Now let me take your attention to when we studied 120 B, punishment for criminal conspiracy. The second category of offense in 120 B was where the offense conspired for would be punished as if he has abetted the offense. In certain, that takes us to a situation where, in that case, a person can also be punished as if he has committed the offense himself. That is the first category. I would recommend you go back and look at 120 B, clause B, and come to 109, and then you would understand what I'm referring to. The second category of offense is where, in case the offense abetted is not committed, I've abetted the offense, maybe it would have been a failed attempt. In that case, what is the punishment that is awarded? Within that, there are two categories. First one is where the offense abetted is for punished with death or imprisonment for life. In that case, even if the offense is not committed, for the fact that I have abetted the offense, I would have a punishment up to 7 years and fine. And in case I am abetting any other offense, got it? So the first category is where I'm abetting an offense which is not committed, and that offense is punishable with death or imprisonment for life. Then I have a 7 years and plus fine as punishment. In case of any other offense, less than offenses which is punishable less than imprisonment for life, that is punishable with simple imprisonment of 6 months or 10 years. In that case, and if even in that case, if the offense was not committed by the person I'm abetting, I would be punishable with I would be punished with an imprisonment of 1/4 of the maximum punishment that can be awarded for that offense. For example, if I am abetting the commission of, say, theft, I am instigating someone to commit theft. If the offense punishable is for 2 years, I would, even if that person has not committed theft, I will still have a liability to be punished with 1/4 of 2 years. That is, do the math. Alright, that is what section 115 and 116 talks about. So you understood 3 categories of punishment. So now you've understood what abetment is, who an abettor is, and what would be the punishment if you have instigated, conspired, or aided in commission of the offense. Alright, now let me take you through some case laws that might help you understand better. So one of the Raghunath Das case, what happened here was A made a casual remark of stating that A would like to murder C. B, hearing on that statement, said, why don't you just do it? Hearing B's casual remark, A went and committed murder of C. The question before the court was, is B liable for the murder of C along with A? The court held that casual remarks cannot be treated as abetment. There must be a mental element involved where there's a desire from the party that the consequence is the result. Only in that case can you punish for the punishment of abetment. In the next case of Pramita Das versus State of West Bengal.